Rosenberg. Thank you.
Thank you, Justice. I'm just going to round off with the strikeout application, which you will find at page 3052, volume 8, 3052.
Thank you. Inside volume 8.
Yes.
Thank you.
On page 3053, there are various strikeouts sought in the replying affidavit of Professor London. The first one is paragraph 46. It should be. It says there 48. It in fact is an error. It should be paragraph 46 at 2614. The words that were sought to be struck out are the words which they simplistically understood to derive from a simple absence of meaningful consultation with the First Nations people. It seems to me that although that's a jibe put in reply for the first time, it's really no more than that. Although if they wanted to take that, make that kind of allegation, it should have been in the founding papers. I'm going to move swiftly on from that. It doesn't seem to me to be particularly consequential. Paragraphs 52.1 to 52.6 at 2615. That is a section seeking to undermine the AFMAS report, and for the reasons I've already indicated, that was available to the applicants, and if it was their intention to attack the report in various ways, and whether it fulfilled its purpose, that was part of an attack that ought to have been made in the founding papers. And to the extent that attack was made in the founding papers, this kind of evidence should have been put up to enable Mr. Orenser and the first respondent to deal with it. Attempts to discredit the AFMAS report with reference to obligations Mr. Orenser allegedly had is material that should have been dealt with in the founding papers. Paragraphs 86.1 to 86.3 at 2626 to 2627. This is clearly new matter in reply. It relates to the challenge to the city's decision, but given the fact that the applicant seems to have lost any conviction as far as that's concerned, it seems to us that absent any challenge, the matter can remain. I would nonetheless make the point that it is clearly material that is introduced in reply, not raised in the founding affidavit. The founding affidavit in this score or this connection contained a bald allegation that there'd been departure from certain policy guidelines, quite impossible to answer in the reply, in the answer. When we pointed that out in answer, that this was typical of the kind of material we were called upon to deal with, these bald, unsubstantiated, broad allegations, well, all the evidence comes pouring out in the reply. It should have been in the founding papers. The exact same point holds for paragraphs 86.4 to 90 at page 2627. This is the biodiversity question. Again, there was just the most abbreviated reference in the founding papers at page 97, paragraph 1937. An absolutely unspecifically, we would say, meaningless reference to biodiversity. And now, in reply, some attempt is made to give some coherence to the case. Again, this is material that must come in founding papers if this matter is to be presented properly. Paragraph 94, it seems on reflection that is, there's no real prejudice there, and given the turn that this matter has taken, it seems to me that it in any event is entirely irrelevant and overtaken by events. Paragraph 99 at 2634, again at 2634, yes, this is where the city's EMD commented on a height issue, and again, another example where it was dealt with in answering papers in a very confined, opaque way, perfunctory allegation, and all the evidence in the form of the alleged comments or view of the city's EMD on this issue is now for the first time presented as the basis upon which this attack is to be relied on. Paragraphs 130 to 132 at 2645 to 2647, we're not persisting with that in the context of relevance and significance. Equally, paragraphs 134.1 to 134.3 at 2648, that seems to have been overtaken. Paragraphs 136 to 137 at 2649. That was introduced as new matter in reply, and we stand by that. Turning to the allegations in the expert or the replying affidavit of Ms. O'Donoghue, paragraph 17, that affidavit is in volume 8 at page 2983. It appears on the face of it to be a fairly gratuitous attack on the ethics and or the professional ethics of Dr. Townsend. We say that that kind of barb at a fellow professional needs to come out. And finally, in relation to, if you just bear with me, in relation to the affidavit of Ms. Prince Solani, the paragraphs that we refer to are all paragraphs which go to undermine Mr. Arendse, paragraph 7. The section there attacking his expertise as intangible heritage expert, paragraphs 11 to 45 and 47 to 51 and 53 all go to directly and indirectly an attack on Mr. Arendse, the AFMAS River Club First Nations report, his methodology, his expertise, the nature, I think, of consultation undertaken. All of that material was available to Ms. Prince Solani at the time of the founding papers. The attack on Mr. Arendse and the AFMAS report and the whole ground of review that this was not just a strong recommendation but a 38.3 requirement is raised for the first time in replying papers, and it's based inter alia on this new material. On those grounds, we submit the strikeout should to that extent be successful. We submit that for the rest, the application should be dismissed. We say it should be dismissed with costs, including the costs of 2 counsel. We say that in the particular circumstance of this matter, the normal rule in a decision such as EMS belting, such as Lloyd versus Lloyd, that's a full court decision, 1993. I'll get the court the reference to that. EMS belting versus Lloyd. Just bear with me. Which is to the effect that in applications for interim relief, the normal order as to costs is if an applicant is successful and obtains interim relief, generally costs should stand over. If the applicant were to be successful and obtain interim interdictory relief, we say the EMS belting principle should apply. But equally, in circumstances where the applicant is unsuccessful in obtaining interim interdictory relief, the normal order in those circumstances we would submit is that costs should follow the result. We submit that there is no reason in the circumstances of this matter why Section 32.2 of NEMA should come to the assistance of the applicants in circumstances where they're not seeking final relief. They're seeking interim interdictory relief in circumstances where the application itself was misconceived. The appropriate remedy would have been to apply for an urgent review, and the manner and circumstances in which this litigation has been conducted are such that in those circumstances, at the interim interdict stage, the normal rule regarding an unsuccessful applicant for interim interdictory relief, namely that it should be liable for the costs of the unsuccessful application, should find favor with the court, and we would ask for an order on that basis. If I could just, yes, the EMS Belting Co. versus Lloyd, 1983, 1 SA 641E. Those are our submissions.
Thank you.
Thank you. Milady, we've agreed amongst ourselves that we, representing the provincial authorities, will go next, followed by the city. Milady, for your convenience, we have set out in our heads of argument the procedural chronology leading to the environmental decisions. You'll find that from page 4 to page 33 of our heads of argument, where we refer to the central documents or categories of documents and their contents. And to avoid repetition, and because it's quite clear that your lady should deal with the papers, I intend at this stage simply to tabulate and mention each of the documents or categories. It's the Heritage Impact Assessment of Hart and Townsend of July 2019. The Interim Comment of Heritage Western Cape of September 2019. The Supplementary Heritage Impact Assessment of December 2019. The UFMAS Report of November 2019. The Final Comment of Heritage Western Cape of February 2020, then correspondence reflecting attempts of the Directorate to engage with Heritage Western Cape, the decision of the Director of August 2020, the appeal process, then correspondence reflecting the Minister's attempts to engage with Heritage Western Cape, and then ultimately the Minister's decision on appeal on the 22nd of February 2021. And we submit that a perusal of these documents, as explained in the Minister's affidavit, will establish certain facts which cannot be disputed. All parties, including the respondents, accepted and agreed that the River Club site has high intangible heritage significance. This is reflected in the Director's decision and in the appeal decision quoted in the Minister's answering affidavit, and I'll simply give you the reference. It's volume 5, page 2144 and following. But, milady, these circumstances were in fact recognized from the outset. And we know that much reference has been made to the heritage impact assessment itself, but I'm going to beg your indulgence by taking you there. It's in volume 6, and it starts at page 2402. It's Annexure AB9. This is the first heritage impact assessment.
Page?
It starts at 2402. It runs to 2521, but I'm going to refer you simply to certain of its provisions. Starting at 2435, Hart and Townsend deal under the heading
Sorry, 24?
2435.
35. Thank you.
It's the heading, the history of the place. And they start in paragraph 4.1 with the historical and geographical context. They start saying what is clear from the historic record is that a number of the Khoi groups were wealthy in terms of the number of cattle they owned. Herds of several hundred to more than 1,000 head were recorded. Farming and moving a herd of this size is no simple task. And they go on to deal with the culture, the farming practices, the heritage of the Khoi before the colonizers arrived. And they go on to deal with it, for example, in the next paragraph. The early inhabitants of the Cape Peninsula farmed with cattle. Cattle need good quality soil, good grass, and fresh water. Therefore, understanding the environmental resources that were available is a key to understanding the way indigenous people use the landscape. He goes on, they go on the next page at 2436 to deal in the second paragraph with the Cape's unique geology, meaning they say that in certain areas the soils contain the necessary trace elements, copper and molybdenum, to raise cattle. And they indicate that there's a certain level of sophistication in their farming practices of the early Khoi in that they understood that at certain times of the year, certain plants were nutritious and they needed to be there. They then go on in this way to deal with the history and the encounters with the first colonizers and what was observed way back in 1652. And it's a detailed setting out of the history of the broader peninsula, the culture, farming practices, and so on, of the First Nations peoples. At 2438, they then, under the heading, the importance of the rivers, deal with the significance of the valleys of the Lisbeek and Black rivers, and then the rivers themselves. They deal with the significance of the rivers and how they were then changed over time. At 2440 and following, we have a heading, Roots of Conflict and the Commencement of Farming. And they deal in detail with the encounters between the Khoi groups and the first colonizers, dealing with respect quite accurately and in detail with what was in fact done by the first colonizers. We see, for example, the reference to the battle with the Portuguese Viceroy de Almeida. They say the account of his death indicates that the Khoi made great use of their cattle as weapons of intimidation to stampede over the Portuguese, the animals being apparently highly trained and responsive to the whistling of the Khoi. It's quite significant, and I think for anyone who is faintly aware of South African history, quite necessary to understand this level of military sophistication, including, and later, farming sophistication. There are detailed references to the encounters between the settlers, the Dutch settlers, and the Khoi, going right on to page 2444, where in paragraph 4.4 they deal with the defended boundary. The Dutch under Van Riebeeck setting up barriers excluding the Khoi from the land along the Lisbeek River with a hedge stretching to Wynberg. They deal in detail with the conflict that took place over that time. At 2448, they continue into the 19th and 20th century history of the site. Then, if I may take your ladyship to page 2471. This is paragraph 6 under the heading Identification of Heritage Resources. Under the heading, the site as part of the floodplain, one sees...
For a moment. You are on page?
2471.
2471. Just see. Thank you.
I'd like to take your ladyship to the middle of that paragraph, where they say the exact places where incidents and confrontation occurred can never be known. But what is evident is that the historic landscape between the Black and Lisbeek rivers marks the site of one of the earliest frontiers that were to eventually herald the fragmentation of the Khoikhoi nation. Although there are no tangible remnants of the actual places of conflict, forts, outposts, or graves, the topography and place survive, albeit greatly transformed by more recent layers of development. Wilderness and wetlands were transformed into farmland and then again to modern suburbia. On the other hand, the Lispek and Black Rivers, the confluence and remnants of the Salt River estuary exist and are still identifiable as such. And in the context of the history of South Africa, this is an historic place of considerable significance. So we say, milady, that this report, read together with the supplementary report, is detailed, it's historically and culturally sensitive, and it is thorough. And this is demonstrated by the fact to which I'll come, that when Heritage Western Cape is ultimately asked what further information is required, they fail to identify any. So we submit that it does not assist the applicants to say repeatedly that the site has intangible heritage significance. This was and is common cause. It's also unhelpful for our learned friend, for the applicants, to seek to lecture the court on these topics. They're topics which are well known and which are not in dispute. The question confronting the director and the minister was the next one. Given these circumstances, what does one do about it? Or, put differently, what consequences should these circumstances have for the environmental decisions in terms of NEMA? The director and the minister explain their reasoning and their decisions, which amount to this. The site is degraded. The Lispek River is canalized, diverted from its original course, and is polluted. The site has been transformed over the years. It now has a golf course, a restaurant, and parking areas, all for private use. This does not reflect in any recognizable form the heritage which attaches to the site. The development can change this. There would be the rehabilitation of the Lispek River, the inclusion of conditions which will reflect and celebrate the site's heritage and its significance, including an indigenous garden, cultural heritage and a media center, a heritage eco trail, an amphitheater for cultural performances, and commemorating the history of First Nations peoples through names and symbols. Moreover, and importantly, a large portion of the site would be made accessible to the public, whereas it is now largely private. In other words, it would be opened up. One may, of course, disagree with their decisions. The residents of Observatory and certain representatives of certain First Nations people clearly disagree. But that does not make the decisions reviewable as a matter of basic legal principle. So, milady, we turn then to the case which the appellants attempt to put up. Of course, in the present context, we know the basic principles. There must be a prima facie right. They're open to some doubt. If there's serious doubt, they cannot succeed. And this, of course, is a threshold requirement. If they don't make it on this level, all of the rest is irrelevant. As pointed out by the other respondents, this right is not merely the right to review a decision. There must be some other substantive right for which protection is sought, and you've been addressed on that topic. But we address the question of whether the applicants have shown that the decisions are reviewable even on a prima facie basis? And the answer, as we will submit, is no. We start, milady, with the much-quoted central piece of legislation, the National Heritage Resources Act, and in particular, Section 38. Again, one's aware that you've been there, but I'm going to ask you to go there again. It's printed for the convenience of everyone in the founding affidavit, and it commences at page 33.
Page 33. Just see.
And I'm going to ask your ladyship to go first to section 38.8, which is quoted on page 37. I'm not going to read it all, but if I may simply sum up what we submit is the clear meaning of what we have here. The consenting authority, here the director and the minister, must ensure that the evaluation fulfills the requirements of, and I'm going to say Heritage Western Cape, in terms of subsection 3. So that's a must. And then comments and recommendations of the Heritage Resources Authority must be taken into account. So those are the two different categories falling under the proviso to section 38.8. 38.3 is quoted at page 35 of the record. It says that the responsible Heritage Resources Authority, read Heritage Western Cape, must specify the information to be provided in a report required in terms of subsection 2A. So in other words, that is the report of the environmental practitioner. That is what the report must contain, provided that the following must be included. And then we have A to G, which set out the particular types of information which must be provided. Your ladyship will note that Heritage Western Cape's role here is in specifying information to be provided in a report. What is to be made of that information is not dealt with in terms of section 38.3. Let me give you an example, which I'm going to get to in a bit more detail later, and that relates to E. So going back to the proviso, provided that the following must be included. E, the results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. What the section requires is that the results of consultation must be reflected in the report. The section does not tell us what those consultations should be. It, in fact, doesn't even say that there must be consultations. The requirement that there should be consultations will be sourced elsewhere. And that would be, for example, in Section 6 of PADGA. What is required here is that the results of consultations must be spelt out. And one understands why that is. The the environmental practitioner will say, this is what we have done in terms of consultation. Factually, right or wrong, this is what we have done. It will then be for the environmental authority to have regard to that and to say, well, I think that that is sufficient consultation or not sufficient consultation. What is clear is that whether or not the relevant information is provided is a factual question. It's not for the heritage authority to rule on it. So the notion that we see expressed quite firmly in the founding affidavit that there was a usurpation by the environmental authorities of the power of Heritage Western Cape to say whether there had been compliance or not is simply incorrect. The environmental authorities will determine whether there's been compliance on a factual basis. I'm not suggesting it's a discretionary matter, but Heritage Western Cape in these circumstances simply has no statutory power which can be usurped. So we know the references in the founding affidavit. You don't have to go there. I'm simply going to ask you to make a note. It's at page 98 to 99, paragraphs 198.2 and 199.2, where the notion of a usurpation is expressed. You can draw a line through that. It can't be the basis of the case. It's gone the way of the provisional protection order. What we see then in the founding affidavit is a misplaced attempt by these applicants, not Heritage Western Cape, to suggest that the information requirements of Heritage Western Cape in terms of section 38.3a to G were not met. The minister, in his answering affidavit, dealt with each allegation with reference to the relevant documentation, showing that all of the information requirements were met. I'm going to give you the reference now, and I'm going to get back to it. It's volume 5, page 2138 to 2151, and 2179 to 2185. So it's not surprising that this whole line of argument was not pursued in the appellant's heads of argument. But now, under new management, the appellants seek to resurrect this line. They don't succeed, and I'm going to get to it in detail in a moment as to why not. But what I'd like to deal with first is the one argument which we find in the heads of argument, which is repeated in the notes on oral argument which we saw yesterday morning. At page 31, 32 of the heads of argument, paragraph 25, we see an argument which stacks up as follows. The strong recommendation of the appointment of a further heritage specialist, and I'm using their words, rose to the level of an information requirement in terms of section 38.3. The argument is without substance, but I need to demonstrate that by going back to the papers, and particularly starting with the founding affidavit at page 70. There's a reference to, in paragraph 133 of the founding affidavit, to the letter of Heritage Western Cape of 13 September 2019. So it's attached as LL11. In fact, it's LL10, and I'm going to get there in a moment. Then we have in paragraph 134, this is now the founding affidavit, the following. The comment concludes with the strong recommendation that a specialist consultant with the requisite expertise in dealing with the intangible aspects pertaining to the wider TRUP area is engaged, and that a supplementary report from this consultant is incorporated into the second HIA. So on their version in the founding affidavit, it's a strong recommendation. There's no reference to it being an information requirement. Where do we find, sorry, before I answer that rhetorical question, may I take your ladyship to Annexure LL10. It's at page 142, and it's perhaps necessary to look at the comment in its entirety. It's at page 152. This is after HWC has set out all of its complaints about the heritage impact assessment. They conclude in this way. Page 152. HWC finally notes that, notwithstanding the unquestionable qualifications and heritage standing of both heritage practitioners who compiled the report, that's Hart and Townsend, HWC is of the opinion that the HIA would benefit from input from a specialist consultant with the requisite expertise in dealing with the intangible aspects pertaining to the wider TRUP area. This input would assist in focusing on, in particular, the strong sense of place and meaning of the site pertinent to the First Nations representatives. It's a strong recommendation that a supplementary report from an expert in this field is incorporated into the HIA. So, with reference to the founding affidavit and Heritage Western Cape's letter, it's a strong recommendation, nothing more. But then comes time for a replying affidavit. May I take you, lady, and I must apologize for having to go to documents which I'm sure you're aware of, but nonetheless, it's volume 7, (2608). Paragraph 31. In any event, says Professor London, even if the minister's interpretation is preferred, and this court holds that HWC's only function in terms of 38.8 is to specify its information requirements, the NEMA authorities still failed demonstrably to ensure that, and now we have it, HWC's information requirements were met because they condoned LLPT's failure to procure and submit a supplementary report from an expert in intangible heritage. So what starts with a strong recommendation morphs in reply into an information requirement. The problems with their approach. The first is a purely procedural one. This was not raised in the founding affidavit as a review ground, and it should be struck out in reply. Your ladyship is aware of our application for striking out. It's in volume 8, page 3128. We move for such an order. But then, milady, substantively, we deal with this in our heads of argument at page 40, but I'm simply going to sum it up. On its own terms, this was a recommendation, not an information requirement. It cannot be massaged into one. Section 38.3, on its own terms, simply doesn't apply. This is not about information. It's about a potential source of unspecified information. This aspect has been dealt with and picked up on. Actually, just bear with me, I just want to get my file out of the way. dealt with in the note on oral argument at page 45, where our learned friend says, straight out of the blocks on this topic, as pointed out above, HWC in its letter of 13 September 2019 required the provision of a supplementary report. They did nothing of the sort. It was a recommendation. And at page 47, we see an argument which proceeds along the following lines, pursued during oral argument. There's a reference to the director's letter, and it said that the director conceded or admitted or said that in fact this was an information requirement. You'll see the letter at page, it's Annexure AB4. Don't go there, my lady. It's at page 2, 3, 3, 5, and 6 of the record. Didn't go there because we have its salient parts quoted for our convenience at page 47 of the applicant's heads of argument. But the point to be made is this. Nowhere does the letter say that the recommendation regarding provision of a further report is in itself an information requirement. It doesn't say that. And it's not one. It's not put up as one in the founding affidavit. And it's important, we would submit, to see how this matter developed from there. At page 26 of our heads of argument from paragraph 45, and again, my lady, you may go there if you'd like to, but I'm sure you're aware of it, and I'm going to simply give you the substance. We deal with the engagements with Heritage Western Cape and the responses to their criticisms of the heritage impact assessment. In the oral note of our learned friend at page 54, we find a criticism of the response of the heritage consultants, where it said that the tone and the content of their report in response was, and then various words are used, problematic and the like. 2 points. First, no basis is provided for suggesting that the response of the consultants was not correct. In particular, information requirements were met. The second point is that Heritage Western Cape itself doesn't come to court to complain about this in any way. There's no basis for these applicants to do so, seeking to ride on the back of an absent litigant. The matter is then picked up by the minister. And again, we deal with this in our heads of argument at page 31. Essentially, the question posed by the minister on appeal to Heritage Western Cape is, what information do you say still has to be provided? What is their response? They fold their arms. The minister asks again and says, if you don't respond, I will then have to decide this matter on what is before me. We get confronted with bold disagreement. So Heritage Western Cape is given every opportunity to answer a simple question to assist the decision maker. What further information is required? And they don't answer. And they don't come to court to say what that information is. So this line with respect that the recommendation somehow transmuted itself into an information requirement has no substance. Now, in oral argument, the appellants seek to revive their line that none of the information requirements in section 38.3a to G were complied with. despite the fact that this was not referred to in their heads of argument. Again, there's no substance to their submissions. May I take your ladyship now, I'm corrected by my learned junior, I think I referred to appellants. I should have said applicants. May I take you now to volume 5. Starting at page 2138, milady.
2138.
Here, the minister refers to the different subsections of 38.3, deals with them, refers to the heritage impact assessment and the other relevant documents, indicating that the information requirements in each was met. Paragraph 39 at page 2140 deals with the mapping requirement, and you'd have heard an echo of that yesterday. He points out that what Heritage Western Cape had contended is that the heritage specialists only partially mapped the heritage resources.
Sorry, which paragraph are you reading?
2140,
214.
paragraph 39. This is now dealing with A. The minister says that's not correct, and he refers to all of the documentation which is available in this matter, and says that the specialists provided maps of 3 separate mapping exercises. So A is complied with. He then deals with B, impact, in paragraph 41, referring to the source documentation, saying this is where the information is provided. He does the same with C. I'm sorry, I said B, I said impact. B is significance. C is impact. And you'll see that at page 2141, paragraph 42. D, which he deals with in paragraph 43, involves the impact in relation to substantive social benefits. Strangely, even that is persisted in today as somehow not having been complied with in a kind of a catch-all way. But there's nothing to it because it's there. And then E deals with a requirement to consider the results of consultation with communities affected. And it's necessary, my lady, to deal with this aspect in a little bit more detail. The first question one needs to ask is what case is put up in the founding affidavit in relation to section 38.3e. You'll find it in volume 1 at page 35. I beg your pardon, I gave you a wrong reference. 35 was the section itself with E. I've dealt with that. It's page 74. And your ladyship would recall that this forms part of the exercise undertaken by Professor London and whoever drafted his founding affidavit at the time, in which they tread through A to G and say that none of these are met. This is what we see under the heading Results of Consultation with Communities Affected and the like. It's page 135, paragraph 135.5. While the formal requirements of the Promotion of Administrative Justice Act 3 of 2000 were complied with. And we have this phrase, the consultation was not meaningful. Where does Professor London get this? He gets it from Heritage Western Cape, which he quotes, where it says, it is clear to the HWC that there's been a lack or avoidance of meaningful consultation with the First Nations groups. HWC is further disappointed that in the instances where comment has been received, this comment has seemingly been dismissed as a difference of opinion rather than a meaningful interrogation of concerns raised. So, what does the founding affidavit then say? It says the formal requirements of PADGA were complied with, but one's left with the vague statement that consultation was not meaningful. To say that consultation is not meaningful does not involve providing any facts. It's the expression of an opinion. An opinion can only be based on certain facts, but the difficulty for the founding affidavit and for the applicants is that no such facts are put up. And there's a reason for that, because they have no facts at their disposal. All that they're doing is riding on the back of Heritage Western Cape. The response to this, you will see at page 2142, back to the minister's affidavit. Paragraph 45. In HWC's interim comment, it stated clearly that the formal notice and commenting procedure had been complied with, but that there had not been a meaningful consultation with First Nations groups. The specialists dealt with this criticism in the HIA supplementary report. An appropriate expert was found and engaged. Section 2 in the HIA supplementary report at pages 4 to 9 dealt extensively with the engagement of the First Nations people, and so on. So, and this was considered on appeal. So that is where this aspect ends with respect in terms of consultation. No facts are provided to support the statement to the effect that consultation was not meaningful. The oral notes and the oral argument attacked the First Nations report. It's already been dealt with by our learned friends for the first respondent, but the point that we wish to emphasize is that that only formed part of the consultation process. So the submissions that we hear relating to consultation simply don't deal with the response in the minister's affidavit. Now, my lady, you correctly, with respect, posed the question at times to our learned friend for the applicants. What is it that should have been done which was not done? It's a simple and direct question. Particularly in this regard, what case is made out in the affidavits relating to consultation? The case is flimsy in the extreme. Apart from the fact that insofar as it's put up, it's fully dealt with the minister, one's left asking these kinds of questions relating to consultation. What is your complaint? Are you saying that the first applicant was not consulted? No, they don't say that. Are you saying that the second applicant, represented by Mr. Jenkins, was not consulted? No, they don't say that. They say he withdrew. Are you saying that there are other people out there who were not consulted, but you don't name them? Are you saying that there's some other defect in the consultation process? For example, that it took place too late, or they didn't listen? You're not told. So, in this context, the submissions of the Amicus relating to consultation will be dealt with later, but may I simply say at this stage what it amounts to? They're interesting but irrelevant. And also may ask this question. Consultation on what? There's recognition across the board, as I've indicated, that this site has significant intangible heritage significance. This is accepted. You don't have to consult on that anymore. Regarding what to do, there's been a wide range of consultation. We've seen that. Are the applicants seriously suggesting that they wanted to be consulted on this notion that the state might expropriate the property? It's not put up in the papers. And with respect, it only has to be raised for one to understand that in this context, and let me not overstate it, it's highly improbable. We can have the state come along. As the law presently stands, they'd have to pay compensation for the property. They'd have to secure it against probable persons who might want to go and live there. They would have to rehabilitate it by removing all of the vestiges of colonialism and subsequent developments, and then they'd have to maintain it. It was never seriously suggested and can't be suggested now. On to the next point, and that is alternatives. You'll find the minister dealing with this in his affidavit at page 2142, paragraph 46, set out in F. There was clearly the consideration of alternatives. Take you, my lady, to volume 6 again. Hart and Townsend deal with this not only in the executive summary, but in the body of the HIA as well. The portion of the executive summary is at page 2406. Now, one must obviously just bear in mind the nature of an executive summary. It's a summary of everything else that follows, provided after the main body has been concluded. Under the development proposal, they say 5 development scenarios have been considered. These include the no-go alternative, a preferred riverine corridor alternative, an island concept alternative, and another 2 which are not financially viable. They go on to discuss this and summarize it in the executive summary, indicating why, in their view, the riverine corridor alternative is the better proposal. The body of the report dealing with this aspect is at 2514 to 2518, where the alternatives are explained. So the notion that alternatives were not considered and therefore the information requirement in 38.3f was not met is simply untrue. Likewise, my lady, mitigation, which is G, 2143, paragraph 47, contains the minister's response on mitigation. It's dealt with. And what follows after these paragraphs, my lady, is the reasoning as explained by the minister in respect of why he and before him the director thought that the riverine alternative, as further developed with the conditions brought up in the first place in the supplementary heritage impact assessment, was the preferable one. So, my lady, it's our respectful submission that when these considerations are taken into account, it will become clear that on the papers as they stand, the applicants have not made out a prima facie case at all for the review of the environmental decisions. At best for them, their case is open to serious doubt. The ladyship would have noticed that in the heads of argument, I'm talking about the real heads of argument, not the oral note, there were some remaining grounds that were dealt with, 3 of them. I'm going to deal with them in a moment, but I want to make the overall submission that these are just make-weights, some of which are of the type so often encountered in appeals dressed up as reviews. They're dealt with in our heads of argument from page 43, but let me simply sum up our submissions in respect of each of them. The first contention says that the minister's decision was irrational. It's dealt with in our heads of argument, page 44. The starting point in trying to assess this submission is, of course, the minister's decision itself. It's in volume 6. It's Annex AB1. I'm going to ask your ladyship to go there. It's page 2198. Here, 2198. It's the first page of volume 6.
Oh, okay. I think I've got the volume 5 here. Let me see, where am I now? Yeah. 2198, yes, I'm with you.
Thank you, my lady. This document starts at page 2198. The first paragraph refers to the appeals which were lodged. The second reflects the minister's ultimate decision that after careful consideration, I'm not going to read every word, he's decided to dismiss the appeals and vary the decision of the competent authority in respect of certain conditions, reflecting his applying his mind. And it's down to the detail of it. Condition E9.1, stormwater management. Condition E9.2, a rehabilitation restoration plan for the rehabilitation of the Rispia Canal. He's applying his mind to it. He then deals under E, I'm at page 2199, with the conditions which are to be applied. And then starting at 2200, he sets out his reasons. He refers to the reasons for the environmental application decision and says these are additional reasons. And he starts with appeal ground 1. There are 19 appeal grounds. The minister works his way through each appeal ground, setting out the grounds, setting out the responses of the interested parties, and reaching a conclusion in respect of each of them, in meticulous detail. Eventually, he comes to his conclusion, which is at page 2324, which is expressed there. The notion that his decision was irrational, and again, let me not overstate it, is inconsistent with the contents of the document and with common sense. There's a flyer which we see in the heads of argument, apparently not repeated in oral argument. It's at our learned friends' heads of argument, page 45, paragraph 103. It's to this effect, that the minister allegedly conflated the requirements of section 38.3b with item 2A1 of Appendix 1 to the EIA regulations. The Minister explains in his affidavit there's no conflation, nor was there any confusion. The provisions are similar. They cover similar ground. The Minister dealt with them together, but he distinguished between the two. On the undisputed facts, the Minister considered the significance of intangible heritage. Then, at our learned friends' heads of argument, they deal at page 47 with the second proviso to section 38.8. It's page 36 of the heads of argument. I beg your pardon, I said page 47. It's page 36. We deal with it in our heads of argument at page 47. I'm simply going to summarize it for you, milady, you needn't go there. It's to the effect that the Minister failed to take into account Heritage Western Cape's comments and recommendations. It's simply wrong. We've taken you to the portions of the record where the Minister goes out of his way to engage with Heritage Western Cape to ask them, what is it that you want? And he gets stonewalled. The notion that they didn't take account of the recommendations with respect is incorrect. It's a recurring theme, milady, but we don't see Heritage Western Cape here to come and explain what their view was. Then at page 38 of the heads of argument on behalf of the appellants, it's the similar type of catch-all phrase that we see, that the decisions were not rationally connected to the information before the decision maker. And the idea that we see expressed is that Hart and Townsend discounted the heritage value of the River Club site because it did not manifest in any tangible form. I've taken your ladyship there. It's simply incorrect. It's wrong. They say it doesn't manifest in any tangible form excepting for the two rivers, but they are at pains to deal with the history of the site, which translates into the intangible heritage significance which we see. Lady, there are various other loose submissions which are found in the note on oral argument and which were repeated in oral argument. Repeated averments to the effect that the conclusions were preconceived. It's not supported by the facts. There's a reference to the Shell case, entirely different facts. And it's our submission, milady, that no case for the review of the decisions of the director and of the minister have been made out in the papers. We also rely on our written heads of argument. I'm not going to read them to you anymore, but they are there for your consideration. We turn then to the submissions of the Amicus. They're interesting submissions, but they don't take the matter any further. The Amicus concedes that it can add nothing to the facts, but there's also this. The Amicus can add nothing to the case as pleaded, as set out in the affidavits in this matter. The submissions on consultation are not based on a case as pleaded. So questions arose from time to time, milady, as to, well, can you show me in the record when consultations commenced? Or can you deal with who might have been excluded from time to time? The first respondent, we understand, wishes to put in a chronology of consultations, and that may be helpful in this regard. But the difficulty is this: where a case is not made out in the founding papers and is not responded to in the answering papers, to then say, well, let's cast about and go and ask ourselves questions like, well, when did it commence? Wasn't it too late? Who might have been excluded? It simply places the respondents in an untenable position. It's not the case which they were called on to meet or which they've sought to meet. Lady, I then turn briefly to certain remaining aspects relating to the requirements for an interim interdict, particularly balance of convenience, and in this matter, the related question of urgency. It is now 11 months since the minister made his appeal decision. Construction on the River Club site commenced in the middle of last year, and considerable progress has been made. The applicants now ask you, on an urgent basis, to grant an interim interdict prohibiting construction on the site. And from the point of view of the provincial authorities, this raises significant concerns, not only for the parties directly involved, but for the people of the Western Cape. What would happen if your ladyship were to grant such an order? Construction would cease, leaving the buildings in a semi-complete state. We've heard about the construction contracts and subcontracts. These would probably terminate with massive negative financial and practical consequences. The workforce would be laid off. And the significant benefits which would follow from the development in terms of employment, broader economic benefits, and the rehabilitation of the river system, the commemoration of the heritage of First Nations people would be lost, probably permanently. So,
Would it
Milady,
not have been
from
better for the developer rather to stop the project and not commence with the project, knowing full well that the project is highly contested? Would it not have been better for the developer to concede and rather stop the project? Because they did write to the developer and requested the developer to
It's
stop.
not for the province to speak for the developer.
But you have spoken for the
But-
developer now, because you are now pointing out all the negative aspects or the prejudice that the developer or the project is going to suffer should the court grant the order, and that's why I'm pausing now.
Can I make this
The
submission, Milady?
developer decided that they are going to proceed and not accede to the request of the applicants to not commence with the building or
Lady,
with construction.
Sorry. As I've said, it's not for me to speak for the developer, but may I make this submission? Well, may I ask rhetorically, what was the developer supposed to do? There'd been correspondence about this matter.
But
it
you
was
have
contested.
spoken for the
Should he simply
developer?
have stopped and waited? But the other point is this. From province's point of view, it's a broader consideration which would equally apply if the application had been brought as a matter of urgency. In other words, if your ladyship would find there's nothing in the urgency point, it's still a question of the balance of convenience. And the province restricts itself really to saying, you've got to look here at the broader interest. There's ample authority for saying that one should do so in the context of the balance of convenience. One's got to look at the interests of the broader inhabitants of the Western Cape and ask yourself, how does the balance of convenience weigh up here? There is a very real prospect that if this project does not go ahead, there will be a considerable loss of opportunity, economic opportunity, employment, a loss of the heritage advantages which would follow. And that is seriously prejudicial on a broader basis. You weigh that up against the types of considerations that were raised earlier today, and they simply don't weigh up. And that's as far as the province takes it at this stage. We don't engage ourselves in the minutiae of exactly how much the developer might lose at any particular stage, which is not to say that this is not relevant. But from the province's point of view, it's a broader consideration in the interests of the people of the Western Cape. So, milady, you have our submissions on urgency. We don't abandon those submissions, but they're in our heads of argument.
But,
So-
the province's interest would be different to that of the developer. So the province, the interest of the province is the community, the broader public economic growth, more particularly during the COVID-19 period.
That's absolutely correct,
The
my lady,
development
and
of
your ladyship would see.
infrastructure. But I think one still needs to backtrack and not move too far forward. Move back and examine the issue relating to the commencement of the construction in circumstances where the developer and the province knew that it was highly contested. Obviously, the decision was not for well, maybe it's not 100% correct to say that the decision makers' decision was not related to the developer's decision to commence construction, notwithstanding all indications that it's a highly contested development. I would imagine it would be unfair for the court to ask the province to explain that. But the province constantly points out where the prejudice lies and what would happen if this court should come to the aid of the applicants. And that is why the court must pause and ask province. But the developer they acted at their own risk to commence construction, knowing that the development was highly contested. So I'm saying one must go back a few steps and then pause there at that particular step before you move fast forward, bulldoze over the whole situation and arrive at the point where one can argue prejudice if the court should come to the aid of the applicant. The developer knew that it was contested
Yes, one understands
and
your ladyship.
refused to stop.
One understands your ladyship's points, but may I make the following submissions? One's got to distinguish between two considerations, those that relate to urgency and those that relate to balance of convenience. One understands the submissions which say you were told don't proceed, and you proceeded at your own risk.
Requested not to proceed.
Our response to that, for what it's worth, would be, well, what are they supposed to do? The applicants are tardy in bringing their application. Does the respondent, the developer, simply sit back and wait until the eventual time when the applicants at their leisure file papers? With respect, no. They're entitled to say...
The construction commenced on the very same day. Is it on the same day that the water decision was made? The decision on the water? On the very same day. Isn't that the position? Yeah.
The decision of the ministry here was on the 22nd of February. But, my lady, I don't want to lose the point that I'm trying to make, and that is urgency is one thing.
It's pointed out issues that impacted on the impact insofar as it...
But if I can follow through on this, my lady.
Yes.
Urgency is one thing. And you would have seen, we take the urgency point as well. You've got what we say in our heads. But your ladyship will distinguish between urgency, where your ladyship may say, well, they proceeded at their own risk, and they can't complain later about the consequences of stopping building. You will distinguish that inquiry from balance of convenience. Of course, part of it is that the balance of convenience becomes even more weighted against the applicants when building has commenced, because there are other inconveniences, prejudices which would follow. But we would say, milady, this. Even if you had to say hypothetically, let's assume that this application had been launched with due expedition, or that your ladyship finds that you're not going to strike the matter from the roll for lack of urgency. That issue is then dealt with. We then still have balance of convenience. And the great deal of the prejudice that the province has referred to would follow in any event. In other words, that you are not going to then have probably all of the benefits that would flow from this development, economic, social, and in terms of the rehabilitation of the area, the commemoration of First Nations people. Those will probably be lost and would probably have been lost in any event, even if there was not an urgency point. And we respectfully ask your ladyship to take that into account. Lady, those are our submissions. If I may just speak to my colleagues for 2 minutes. The application be dismissed. We too ask for costs, including the costs of 2 counsel. We say that's justified. We say that the BioWatch case is not applicable here. This case was not brought to assert any constitutional rights. So we ask for a costs order as well, bearing in mind, of course, that costs are in your ladyship's discretion. As the court pleases.
It appears that we are on track. We have so many here, I don't know who's the spokesperson, but it appears that we are on track in terms of time management, are we? We on track?
Yes, I think so, lady. I know that my learned friend for the city, he asked me if I couldn't please continue till 4 o'clock because he wants to start tomorrow.
No, we can start tomorrow.
You might want to indulge him.
No, we can start tomorrow. Are you happy to do that? That is fine. But tomorrow is Friday, then you may have to sit a bit later tomorrow. It doesn't matter. It will be our last day.
Having the night to prepare should shorten the argument as well.
Sorry, can you just remove your mask, please? I didn't hear you.
Having the night to prepare will shorten my argument as well tomorrow.
Yes.
So that'll take up less time. Thank you.
So tomorrow will be 21. Court then adjourns until tomorrow.